Thank you all for joining us today for our webinar titled, What's the Big Deal About Prior Written Notices? My name is Kelly Carnahan, and I will be hosting this webinar with my colleague Susie Lund. We are the training coordinators here at Ask Resource Center. Before we begin, I'd like to take a moment to share about Ask Resource Center. We provide individualized support, collaborative advocacy, training, resources, and leadership development for Iowa families of children with disabilities or special healthcare needs from ages birth through 26 and the professionals who serve them. So today our guest speaker is Stephanie Petrillo from Disability Rights Iowa. Stephanie joined Disability Rights Iowa in 2022 after graduating with honors from Drake Law School. While at Drake, Stephanie focused on public policy and civil rights law and interned with nonprofits and government entities. This work highlighted for her how the issues people with disabilities face are connected and intertwined, and the important role that she has when advocating for her clients. Prior to law school, Stephanie graduated from Grandview University with a bachelor's degree in history and a minor in the Logos Honors Program. Stephanie's work at DRI included helping clients with special education, employment, guardianship, and accommodation issues, as well as educating lawmakers on these topics. In her free time, Stephanie enjoys spending time with her friends and family, reading and learning new things, and playing with her basset hound named Fred. Please join us in welcoming Stephanie.
Thanks, Kelly. As you said, my name is Stephanie Petrillo. I'm a staff attorney with Disability Rights Iowa. And I'm going to be talking today about the big deal about prior written notices, what should be in them, and how parents and professionals can use them. A little about DRI before we get started. Disability Rights Iowa is the state's protection and advocacy agency. There's one of us in every state and territory in the U.S. The P&A system was created in 1975 after an investigative journalist exposed some pretty horrific conditions in state-run facilities, nursing homes in New York. So Congress's response was to create the P&A system. We have a little bit more authority to go in and investigate and monitor these places to make sure that abuse and neglect hasn't been occurring. Over the years, our work has expanded through 9 different congressional grants, which fund the vast majority of the work that we do. We also get a little bit from private grants and donors, but again, the vast majority of our work is through these grants. That money allows us to provide advocacy and legal representation for Iowans with disabilities for their disability-related issue. So that includes employment, guardianship, special education, ADA accessibility accommodations. We do Medicaid appeals. Again, that monitoring investigations of facilities is kind of our bread and butter. We also do representative payee reviews, and we have a team that does benefits planning for Iowans who want to work and know how that employment might affect their benefits. So a disclaimer before we get started, I am an attorney, but I am not your attorney. This presentation is not legal advice, it's only for educational purposes. I can't address specific situations, but I hope to provide a little education today on prior written notices that will be helpful to you. All right, so what is a prior written notice? This image that you see here is sort of the top half of a prior written notice when you receive it in the Achieve system. So a prior written notice is documentation of what the IEP team has discussed and what decisions were made. It is required whenever there is a proposed or refused change made within an IEP meeting. Is also required if the team makes written amendments outside of the IEP team. So parents in school can agree to make a change without calling a full IEP meeting, as long as that change and agreement is in writing. And that still requires a prior written notice. It must be given to parents prior to any changes occurring, hence prior written notice. And it has to be given within a reasonable amount of time for the parents to consider what's being proposed, what's rejected, and consider whether they're going to exercise their due process rights. What counts as a reasonable amount of time is really a term of art in the law. Generally speaking, we're talking 2 weeks if possible. Sometimes, depending on the situation, more notice may be required. Sometimes it's not possible to give that full 2 weeks. So generally, we just want to have parents have that notice in their hands with enough time to really go home, think about it, and consider whether they're going to exercise due process rights and make sure that they fully understand what changes are being made or what was refused. So, when is a prior written notice required? There are four times that we want to see a prior written notice issued: when we are making changes or when the school is refusing to make a change regarding identification of the student as having a disability, evaluating the student. So we're talking that first evaluation, the initial evaluation, the triannual or every 3 year evaluation, or if the parent has requested that an evaluation occur between those 3 years, we also want a prior written notice to take place. Whenever there is a change in placement occurring, we want to see a prior written notice. We'll get a little into what may or may not constitute a change in placement further into the presentation. And then also, how are we going to be providing that student the free appropriate public education, or that FAPE? When we're making significant changes to how that is going to be provided, that's when we want to see a prior written notice. Okay, so again, what kind of changes or refusals require prior written notice? So we'll get a little more technical here. Again, evaluations, that initial evaluation, the triennial evaluation, or any other evaluations that the school team is conducting. When we're talking about placement and least restrictive environment, so when placement is changing, we want a prior written notice. Now, what constitutes change in placement? Placement is sort of a misnomer or misleading statement, because a change in placement doesn't necessarily mean the physical location of the student's education is changing. It could be the case that the physical location is changing, but their programming, their instruction, their access to peers, access to general education, none of that is changing. And so, even though the physical location may change, the actual LRE has not changed. So that's kind of how we differentiate that. But if we're getting changes to, again, that access to general education curriculum, access to non-disabled peers, changes in access to non-academic or extracurricular activities, or placement changes that are really amending the IEP to a significant degree, we're going to want a prior written notice. And again, this applies when a parent has requested that change and the school has refused. We're also going to need a prior written notice for changes or refusals to specially designed instruction. This is referring to the areas that that specially designed instruction is occurring in, the amount of minutes that the student is receiving, and just whether we're adding or subtracting that SDI. It is not specifically referring to the like specific curriculum itself that is being offered in SDI. So let's say the student needs math SDI, and we are using XYZ curriculum, and now we're going to change to using ABC curriculum. That change in curriculum doesn't require a prior written notice. But if we're changing the areas or the time, and again, the location of that SDI, if we're impacting LRE, then we're going to need a prior written notice. We also need prior written notices for changes or refusals for related services. Related services is a very broad category in IDEA. Any service that is necessary for that student to receive that FAPE is a related service, minus some more technical medical things that would require a doctor. So if we are adding related services in, like speech therapy, occupational therapy, administering medications, things like that that are relevant to the student being able to access that education, it's going to trigger prior written notice requirement. Likewise, any changes or refusals to accommodations, strategies, and supports in the student's IEP are going to trigger a prior written notice. Again, this is kind of like with the specially designed instruction, where there's kind of a sweet spot with the level of specificity that we want. Um, Again, if there's a assistive technology accommodation in the prior written, or excuse me, in the IEP, and we're changing the software, but it's still speech to text, right? But we're going from one speech to text software to a different one. That doesn't necessarily trigger prior written notice. But if we're adding speech to text, or we're removing it, or the parents have asked for it to be added and the school's refusing, that's going to trigger prior written notice. And then perhaps one of the biggest ones in my mind is IEP goals and measurements. So again, this is, are we adding IEP goals? Are we ending IEP goals? Are we amending IEP goals? And the same thing, are we changing how we are measuring the student's progress? And so if we are changing the goal from we're collecting all behavior data in one goal to now we're going to separate it out. We're going to collect physical aggression, verbal aggression, refusals separately. That's going to trigger a prior written notice. Likewise, if we are not changing the IEP goals year to year, that I'm going to want to see a prior written notice as well as why those are not changing. There may be a very good reason for us not to change that goal. From one annual meeting to the next. Maybe the student is super close to meeting that goal, and we want to give them that opportunity, and then we'll reconvene and change the goal. Maybe we are making other changes that we want to make sure the student doesn't lose progress. Like we're removing that speech to text accommodation. We're going to fade that out, and we want to make sure that the student doesn't lose progress on their IEP goal. That might be a reason to leave that IEP goal as is. And again, we want that documented. And just a comment about measurements. If we're changing, a lot of times with these goals, we're using rubrics. If we're going to change that rubric, that's a change in the measurement tool. And I like to see prior written notices for that as well, so that we know we've changed the tool that we're using. We might see a little slight shift in the data. Maybe that's because we're tracking data better. Maybe it's because we're not tracking data as well. That's important to note in there when we're changing the tool that we're using to monitor and measure progress. Okay. Sort of touched on a lot of these already, but there's certain times that prior written notice is not going to be required. Again, change in location that isn't really affecting the student's placement. They are still accessing general education, curriculum, and peers to the same extent. Maybe we're just moving from one special education room to another special education room. That's not going to trigger a prior written notice. Again, changes in curriculum, we don't need to get that specific unless there's always caveats to these, right? It's very fact specific. If there is a very intentional and specific reason we're using one type of curriculum and that is a necessary part of the student's FAPE, maybe we want to put it in there, and maybe we want to know when that changes. Observations or data reviews, these I differentiate from evaluations. An evaluation is truly conducting new assessments, gathering new data, doing new interviews. It's new information that we're then going to use. If we're observing how the current accommodations and goals are working, or reviewing data that has already taken place, we're not really stepping into the realm of evaluation. And so it does not require prior written notice. Again, you can always err on the side of caution and issue a prior written notice, even if you don't need to, but it wouldn't be required here. Minor schedule changes, like, we're moving student from A lunch to B lunch. That's not going to require prior written notice. Or we're moving math from second period to eighth period. Not going to require a prior written notice. Disciplinary removals under 10 days. This comes with a caveat. So the first 10 days school removal, we're not triggering procedural safeguards. We're not triggering manifestation. They should be documented appropriately, whether they're, as suspensions, as in-school suspensions, all of that, but we're not triggering prior written notice. When we may trigger prior written notice for disciplinary removals, let's say we have the manifestation to termination review. We say, yes, it's a manifestation. Um, and because it's a manifestation, we're not going to continue the student suspension. However, in order to address the behaviors, we are going to change the student's placement. Because we're changing placement, now we're triggering prior written notice. Likewise, if the answer to both of those questions is no, and that's going to lead to a 45-day removal to interim alternative education placement, you're going to want a prior written notice. We're changing placement. There's probably going to be some significant changes to the student's IEP of how those services are provided. And then finally, staffing changes. Staffing changes are within the school's purview to make those changes. Again, unless there's a specific FAPE argument to be made. I have made those arguments in some cases where staffing is very specific to that student. Maybe that student has a trusted person that we have said they can go to when they're escalated. And if we change that staffing person, it's going to not address the escalations. Maybe it'll escalate the student further. Those sort of things we would have specifically listed in the IEP. But if we're swapping one para for another para, generally we're not going to be documenting that through prior written notice. All right. So what must be in a prior written notice? This is an example of a prior written notice from the Achieve system. I have redacted, so I have actual examples throughout this PowerPoint. I've redacted all of the identifying information, but I wanted to give a real life example of what they look like. So within them, we are looking for a description of the action that was proposed or refused. Again, we want this description to have a good degree of specification. We want, when I get a case, the first documents I go to are these prior written notices. I want to know, what have we tried? What's been going on? What have the parents been asking for? What has the school been saying about the student's progress or the changes that we're making or not making? So this is really kind of the quick version to get at, where are we at? What is going on? What has been happening? And so if the description just says change teaching strategies, that doesn't give me a lot. What strategy was changed? Was the previous strategy not working? Why wasn't it working? Why did we pick this one versus the other one? So the description of the action proposed or refused, again, it's important to have a good degree of specificity. With all of these, I will point out that being more specific protects everybody and is in everybody's best interest. It can protect parents and their procedural due process rights. It can be a really important piece of evidence when, if we have to go to dispute resolution to say, here's what happened, here's why the school said it happened, and we don't agree. And it can be a really helpful tool for the school side as well. If there may be things that the school has done that a parent doesn't agree with, but they've properly documented what they did, why they did it, what other options were considered, and why they went this route. That may meet the threshold of being reasonable and appropriate under IDA, even if a parent disagrees. And so prior written notices are essential to making sure that everybody is on the same page and they can be helpful to everybody involved. And in order to be helpful, they need to have a good degree of specificity when it comes to these items. So we also want to see an explanation of why the action was proposed or refused. Why are we changing that teaching strategy? Why are we not changing that teaching strategy? We want to know what information was used to make that decision. Did we do an evaluation that told us this teaching strategy isn't working? Did we conduct observations? Did we get input from parents or the student or a third-party provider? What was used to come to this decision? Everything that we do in IEP meetings needs to be data and information driven, not just kind of on a whim or not just because a parent asked for it or because somebody threw it out in a meeting. We want it to be backed by the data and the information that we have. Likewise, we also want to list out what other options were considered. Sometimes there may truly not be another option that was thrown out. Maybe somebody suggested we add this service to the IEP. Everybody thought it was a great idea. We added it in. There really wasn't much discussion about, well, maybe we do this instead. Um, but in a lot of cases, there are other options considered. And in a lot of cases, it's do we do A or not do A? And so that those are two options that we're considering. And so even though it may seem obvious, we're going to do A, why was it rejected to not do it? We also want to list factors relevant to propose or refuse action. This can kind of be a whole category of things. It can be input, student input, third party provider input. Um, this is kind of the space to put kind of the catch all, right? Of what other information and context is important that we used to inform this decision making. And then finally, we're going to have a statement of parents' procedural safeguard rights. These are boilerplate in every prior written notice. It automatically prints them in there. And then we want to give the parent a contact person who they can reach out to if they have questions about the prior written notice. All right, we're going to go through some examples of prior written notices. These are actual prior written notices that I have received through helping clients. Again, all personal identifying information is redacted. So you'll see some blank spots. That's information I've redacted. So here's our first example. Student is still eligible in the area of social emotional behavior. That's the proposed action, is that the student remain eligible. The reason is because the student requires a para to transition and for behaviors, and they require it for X number of minutes per day. The student's goal focuses on aggression and reducing to one or less per week. Other options the school considered and why they weren't or why they were rejected, no other options and no other relevant factors. Okay, so there we go. I'm seeing reactions roll in. Yes. So not so great for a few reasons. One, the student remains eligible in the area of social emotional behavior. Did we do an evaluation? That's not really indicated anywhere in this prior written notice. How do we know that they're still eligible? Also, when you get into the reason, it's sort of putting the cart before the horse, right? We're saying that they're eligible because they need a para, rather than they're eligible and they need a para to support them. It's also not referring to any specific data or observations, what behaviors, what are we trying to get at here? Other options considered. Well, the team they say that there were no other options considered, but again, this is kind of one of those they were found to still be eligible, which means there was an option that they weren't eligible any longer. So why was it decided not to go with they weren't eligible anymore? What again, did we do an evaluation? What data do we have to say that's not the way to go? And then when we're finding a student to be eligible in social emotional behavior, I can almost guarantee that there's going to be other factors related to their social emotional needs more than they just need a para. That there's probably a lot more information that could go into this and be helpful to again to everybody involved. If a later school team is going to pick up this prior written notice, it doesn't really tell them much about the student and why they were found to still be eligible. All right, next one. The school is proposing to keep the IEP as written. And the reason essentially is the parent is in agreement because she was present at the IEP meeting. no other options, no other factors. What do we think on this one? Yep, seeing a lot of shocked faces. Yes. Um, so this is kind of one, again, if we're keeping the IEP as written, we're not making any changes at an annual meeting, that's a red flag. I want to know why. There may be good reason why we're not making changes. This doesn't tell me anything about those reasons. Um, and so and the justification for keeping the IEP the same is parent agreement. Parent agreement is not enough. Just because parents agree doesn't make it legal or appropriate under the IDEA. The IEP team still has to follow procedures, still has to um, consider all of the relevant factors. I'll also note that just being present at an annual IEP meeting is not agreement. So we're kind of getting a little into meaningful participation with that one as well. And I also find it hard to believe that there were no other considerations when we decided to keep the IEP as written. Again, it's one of those binary choices. We decided to keep it as written, so another option was to not keep it as written. So why didn't we make those changes? Okay, and last one here. We are going to, it's proposed to add English and biology. We're adding specially designed instruction and an executive functioning goal. And we're going to add accommodations for a preferred staff member. We're adding those classes because the students shown tolerance and stamina for longer school day. But we later on, you'll see, we don't want to go directly to a full day. Yeah, so I'm seeing clapping emojis rolling in. I think maybe by the length of this prior written notice alone, that kind of gives it away. But yeah, this is a good one. They don't necessarily need to be this extensive, but this was a really good one. It talked about the student wanting to be at school for longer, but we weren't going to add a full day just yet. Why we decided to add these classes? Well, because they're core required classes. We're adding a goal, so it references that data was collected that indicated we need this goal. And so, we also have the accommodation plan, which is again appropriate level of specificity. This student, we knew who those individual people were. But it also gives us room to change that up. If the student has a falling out with one person, we can change who that kind of trusted adult is. So yeah, this was a really good one that was really supported the decisions that the school made and why they made them. All right. So this is my my little soapbox here of why prior written notices are so important. If it's not in writing, it didn't happen. At least in my world, right? If you've asked that an evaluation occur, or if a parent's asked an evaluation occurred and the school said no, and that's not documented anywhere, that's really hard for me as a parent side attorney to prove it was asked for and denied and maybe inappropriately denied. You're not relying on other people's notes or memory or he said, she said. There's no ambiguity in what was agreed to, which is super helpful. We're all very busy, and I take notes on every single conversation I have, just so I can refer back to and keep track of what we talked about. And I think that's just important across the board, but especially when we're talking about key changes or refusals to make changes to a student's education. It documents what those decisions were and the reasons behind those decisions, which again protects everybody involved. It supports everybody involved. Again, everybody's on the same page. It's a good record of what the team has or has not tried and whether that has worked. So again, if the student, we've we've been trying different teaching strategies and things over the years, and some have worked and some haven't worked. Prior written notices are a great place to go for later staff members down the road to look back. Maybe you want to propose that we use XYZ teaching strategy, but you can go and look at prior written notices and see a year ago, we took that out of the IEP because it caused escalations. Well, now we don't need to trial that again. We know it didn't work and we're not going to do it, and we're not going to set the student up for potential failure that way. Again, helpful for new team members or advocates. Again, myself, these are the first place I go to figure out what's been going on. I use them all the time. They're kind of my quick guide to understanding the situation. It records if the team says that they will do something later or come back to it. I've had times where, okay, we want to try this intervention first, but if that doesn't work, then we'll do XYZ. And so if we put that in the prior written notice that, for now we're rejecting doing that other thing, but we're gonna try this first, and if that doesn't work, then we'll come back and consider this. It just keeps everybody accountable. It keeps it on your radar, and it makes sure that if that doesn't happen, then you have the ability to kind of go back and say, okay, why didn't that happen? Should we do that now? It's just good record keeping, and again, keeps everybody on the same page. It's a good place to document parent concerns and disagreements. So again, in that kind of other factors section, and I think there's also like another comments section. Parents, if you are disagreeing with what the team is doing, that is an excellent place to document your disagreement. And that way, the school can't come back later and say, well, we didn't know that the parent didn't like this thing. They never voiced that, or they never shared this concern with the team. If you have those documented, there's no question as to whether the school team was on notice that might be an issue. Again, great evidence in dispute resolution, and again, great evidence on both sides. If there's helpful information in there for a parent to prove up the claims that they have, there may be helpful information for the school side to disprove the claims that the parent has. So again, making sure that these are robust and detailed helps everybody. And then again, it contains that key information for parents about their rights and who to contact with questions. A lot of times, I know you get those procedural safeguard manuals that are thick and legalese, and it's just a good reminder that you have procedural safeguard rights if you don't agree with what the school's doing. And if you have questions about what's in the prior written notice, here's your contact person. All right, so this is more for parent side. I'm a parent side attorney, so that's kind of the lens I see a lot of these things through. So how can parents use prior written notices? I like to try to end every IEP meeting with a review of what was proposed or rejected and why. That way, we have a list of next steps and who's going to be doing what. We also make sure that we don't leave anything of like, did we come to an agreement on that? I know we discussed a couple options, but which one did we actually pick? It just helps kind of wrap up the meeting and make sure that we've covered everything that we need to cover. We've come to an agreement on everything that we need to, or if we haven't come to an agreement, we document that as well, and we know that next meeting that's something we got to pick up. And if there's disagreement about what was agreed to or rejected, that can be resolved there and then at the meeting. You don't have to wait for the prior written notice to come out 2 weeks later, and maybe your memory isn't as great and you can't remember, which option we picked. I like to set calendar reminders for everything. Just for myself, there's a lot going on, and so I put just little calendar reminders. And usually for prior written notices, we'll try to put one about a week out, depending on the situation, but definitely at that 2-week mark. If I haven't gotten the prior written notice at that 2 weeks, I'm going to be bugging the school's attorney to get that. I'm an attorney. I have to go through the school's attorney, but parents and non-attorneys, you can contact the school directly to get those prior written notices. If there are dates in the PWN of when something is going to start or be done or ended, I like to add those to my calendar as well. So maybe we know that on, a month from now, we're going to fade XYZ. And so I know in a month from now, if I get a call from a parent saying it's day two of fading this accommodation and things have gone off the rails, I have that context of what's going on, what might be leading to that. Um, Again, for parents, if the school is proposing or rejecting something you disagree with, ask that it be documented on the prior written notice. One, this may sometimes cause the school to kind of pause and ask, do we want that documented that we're rejecting that? But a lot of times it just helps protect your safeguard, your due process rights as a parent, that you have documented that disagreement, why you disagree, and then on the flip side, it's also helpful for the school to say, yes, the parent disagreed with this decision. We move forward with it anyways, and here's why. And that could protect the school in dispute resolution. Um, Parents, any concerns that you feel have not been addressed, you can also document in the prior written notice. If, for example, your student started having some mental health concerns and you brought that up with the school and that was kind of set to the side. That can be something you can document in the other relevant factors section of, again, putting the school on notice that this might be a problem and documenting that they've been put on notice. If there is an error on the prior written notice, ask the school to fix it, but also keep the original version as well. I've had a situation where I got a draft of a prior written notice that included something that the team had not discussed and had not agreed on, and that the parents did not agree with. And I, push back on that, and then I get the final prior written notice, and that's nowhere in there. So because I have both of them, I can show this was something they were going to do until I made a stink about it, and they pulled back. So it's just good to keep both copies. If there's an amendment or if there's a edit to a prior written notice, and schools, if you are amending a prior written notice in the new one, make sure to reference back to this is an amended prior written notice of this January 1st prior written notice. And then finally, when I get a prior written notice, I'm going to go in and compare the changes that the PWN says to what the IEP says. If the PWN says we're changing SDI minutes from 1 hour to 2 hours a day, I'm going to go into the IEP, go to the SDI section, and make sure that that's reflected in there as well. So you want those documents to be lining up, just so everything is on the level. All right. So that's kind of the quick overview, hopefully helpful, about prior written notices and why they're so important, how you can use them, and what should be in them. So I will open it up for questions.
Thank you, Stephanie. That was a great presentation about prior written notice. We really appreciate you being here today. We do have a couple of questions that have come in the chat, and we would appreciate if anybody has more questions, please feel free to add them to the chat. You just talked about this one, but let me make sure that see if there's anything more. Can parents create their own prior written notice if the school refuses to put specific issues into the PWN, or some suggestions on how to handle that situation?
Yeah, absolutely. So parents can't create their own prior written notice official document. But how I would handle that, again, if it's not in writing, it doesn't exist. So if I get a prior written notice and there's things missing in it, I will again, I will send it back to the school's attorney because that's who I have to communicate with. But I will send an email back saying, I just want to document we also talked about XYZ and we decided ABC because of these reasons. And here, pretty much what you want to see in that prior written notice, respond back in writing, typically an email with all of that. And then keep that email for your records as well. Um, it doesn't necessarily mean that it'll become part of the prior written notice or even that it will become part of your child's educational record. But at least you have some documentation that there was more to this prior written notice that needed to be in there. And then if you do end up in dispute resolution, I can use that email to say, again, school was on notice that these things were missing as well. My biggest piece of advice across the board with everything is document, document, document. And then when you send that email, it also gives the school the opportunity to agree with you and say, oh, yeah, we forgot to put those in, or push back with any disagreement, or no, remember, we actually agreed to option B, not option A. And so their response back to you can also be helpful.
Great. And I think you answered the most recent question in the chat with that, Stephanie. What is the best way to make sure your request is documented? Do we request it in an email? It sounds like an email or is probably your best advice.
Yes, anything in writing is always going to be the best. I will also tell clients if you have a phone call with the school, you can always follow up that phone call with an email saying, I just want to, follow up. We talked about items 1, 2, and 3. This is what we discussed, and this is the resolution we came to. Um, Again, if I can get it in writing in some way, that's always preferable to, well, I had a conversation with the teacher waiting in the bus line. I, I as an attorney can't do much with that if it's not in writing.
And a follow-up to that, Stephanie, is there a list of who should be on those kind of emails? Case manager, special ed teacher, gen ed teacher, what would you suggest?
Um, as with a lot of things, it's kind of fact specific. I would say at least everybody at the IEP meeting. Um, and then I'm trying to think. Yeah, everybody at the IEP meeting. And then, if let's say it's relating to a speech therapy issue and the speech therapist didn't happen to be at that meeting, obviously then I would include the speech therapist as well. But yeah, I think the core IEP team is going to be your go-to, and then it really just depends on the specific facts of the situation as to whether you would include anybody else.
Great, thank you. I'm going to back up just a little bit. This came a little earlier in the webinar. Could the eligibility/evaluation determination be combined with the initial IEP meeting prior written notice? So it would contain both the eligibility evaluation and IEP meeting in one.
And so with the initial evaluation, that is generally going to come before any identification or your first IEP team meeting. So just timing wise, maybe not, but you can include as much stuff into one prior written notice as you want or as is appropriate for that situation. I think you don't need individual prior written notices for each one of those things. No, I think if that answers the question.
So if it all occurred in that one meeting, you would just make sure that all those pieces are documented on one.
Yes. Yep.
Great. Thank you. Here's another question. In addition to the time requirements for when a prior written notice must be delivered, are there any legal requirements about how a prior written notice must be delivered or shared? Meaning email, post, in the mail, snail mail, etc.
Yeah. I don't. I would have to go back and look at code specifically. I don't think that there is a specific this shall be, hand delivered or delivered in mail within 3 business days, sort of thing. But there is a general provision of communicating in a parent's preferred method, and in a method that is going to be effective for that parent. So I've had clients who do not use technology whatsoever, and they need a physical copy because they're not checking email. Um, and vice versa. I've had parents who have disabilities of their own and need that electronic copy in order for it to be accessible. So it's really kind of parent preference. And if it's becoming an issue of the parent has asked, I want prior written notice in, I want it in my student's backpack, paper copy, or I want you to mail it to me, and the school's not following through on that, that's something I would start to try to again set up that documentation that you have asked for this in a different form, and the reasons for that. If it's an accommodation that the parent themselves needs that accommodation, now we're kind of getting into multi-layered issues, with not accommodating parents, not providing meaningful access, um, and then I will also note that there's a requirement that documents be in the parent's preferred language as well. So um, if a parent needs a translation, it should be translated. And I believe AEAs and Department of Ed have resources to help schools with those translations as needed. But I would say just defer to parent preference as much as possible.
It's all about that meaningful parent participation, right? If we're not
Absolutely.
accessible to it, then we need something to be accessible. Thank you.
Absolutely.
All right, another question. What is a good timeline for requesting a reply to the request? 5 school days, 2 weeks? What are you thinking?
Oh boy. Again, a lot of it is very fact specific. It depends on what the request is. If the request is we need, I want to bump up the SDI minutes from a half hour a day to an hour a day, that's not going to take a lot of logistics likely on behalf of the school. So, a few days to a week might be appropriate there. If we're talking, we need to you want to add an executive functioning goal, that we're going to need to collect some data for to figure out what our baseline is and what the goal should be and what's appropriate. That's going to require a longer period of time. And so for that one, I would maybe do 2 weeks for data collection and then maybe either hold an IEP meeting to talk about that, or um, talk about a written amendment to add that IEP goal. It's really kind of fact specific into what the actual request is. Um, without kind of an outlier, without more information, I think 2 weeks is kind of that sweet spot. But again, there may be things that 2 weeks is not a reasonable time frame. It really just depends on what you're asking for.
Thank you. I really like your suggestion of putting it in your calendar because, like you said, we're all so busy that if you're expecting a prior written notice in the next 2 weeks, to give yourself a little notice in your calendar, and then you can look back and go, did I get that? Did I not get that? So
Yep.
that's a great idea. All right, I am not seeing any more questions in the chat. I'm going to go ahead and round us all out. And if we get any more within the next little bit, then I'll make sure to address them. But I just want to thank you again, Stephanie, for this excellent presentation. This was Stephanie Petrillo from Disability Rights Iowa.